Hello, my name is Richard Albert, and I'm here today with Cora Chan, an assistant professor of constitutional law at the University of Hong Kong, Faculty of Law. And today, Cora is going to talk with us about democratic reform in Hong Kong. Cora, thank you so much for talking with us today about this important and timely subject.
Thank you, Richard, for inviting me. It's my privilege and my pleasure. Thank you so much.
Oh, you're welcome. You're welcome. So I'd like to begin by asking you about the protests in Hong Kong regarding the right to vote. But before we do that, could you situate for us the constitutional status of the relationship between Hong Kong and China?
Yes, sure. So Hong Kong had been a British colony for over 150 years, and in 1997, Hong Kong was returned to Chinese sovereignty. And since then, the relationship between China and Hong Kong has been governed by the Hong Kong Basic Law, which is the constitutional charter. You can call it the mini constitution of Hong Kong. The Basic Law sets out that Hong Kong shall enjoy a high degree of autonomy and practice economic, legal, and social systems that are separate from the socialist systems of mainland China.
Okay, so that's useful background. Now, tell us what's going on in Hong Kong. What are the people of Hong Kong protesting against or for?
Protesters have been demanding genuine democracy in Hong Kong. In the past, Hong Kong's chief executive was returned by an election committee which was dominated by members who were pro-Beijing and pro-business elites. And the electorate base of this election committee had never exceeded 7% of the general electorate, so it's not highly very representative. And in 2007, the Chinese government promised that the chief executive could be returned by universal suffrage in 2017. But in August this year, Beijing's National People's Congress Standing Committee, commonly known as the NPCAC, this committee made a decision to impose tight restrictions on how candidates for the chief executive election are to be returned through universal suffrage. These restrictions on nomination procedures would enable the Chinese government to control who can run for the election. And these restrictions include, firstly, candidates shall be nominated by a nomination committee, and the composition of this nomination committee would be based on the existing pro-Beijing election committee. Secondly, a person can only become a candidate if he has obtained the endorsement of more than half of the members of this pro-Beijing committee. Finally, the number of candidates is capped at 3. Now, Beijing insists that even with these constraints on the nomination method, the resulting election model would still qualify as universal suffrage because the general electorate gets to pick on a one-person, one-vote basis among the candidates screened by this nomination method. The recent protests are in large part a protest against this decision of the NPCSC, which is seen by many as Beijing's attempt to impose fake universal suffrage on Hong Kong and pass it off as the real thing.
So there's a lot going on here. So you said that the NPCSC made a decision that imposed restrictions on this nomination selection procedure. I guess, what is the constitutional basis for that decision? And perhaps more broadly, what are the constitutional provisions that govern constitutional reform in Hong Kong?
Thank you very much. The starting point is to look at Article 45 of the Basic Law. This is an important provision. This provision states that the chief executive shall be returned by election or consultations and appointed by Beijing. This article states that the ultimate aim of democratic reform in Hong Kong is the selection of the chief executive by universal suffrage upon nomination by a broadly representative nominating committee according to democratic procedures. The precise method for electing the chief executive is stipulated in Annex 1 of the Basic Law, and Annex 1 states that if there is a need to amend the election method, the amendment would have to be approved by Hong Kong's legislature, endorsed by Hong Kong's chief executive, and finally reported to the NPCAC for approval. So according to the plain text of the Basic Law, the NPCAC only takes a backseat role in approving amendments to the election method after Hong Kong's legislature and chief executive endorsed the changes. But things are complicated by the fact that, according to Article 158 of the Hong Kong Basic Law, the final power of interpreting the Basic Law is vested with the NPCSC. This complicates things because, according to the NPCSC's interpretative tradition, interpretations of law can add things to the law. So under Leninist legal tradition, the line between interpretation of law and amendment of law is extremely thin. And in 2004, the NPCAC issued an interpretation of Annex 1 of the Basic Law, the effect of which is to give the NPCAC an initiating role of deciding whether the election methods in Hong Kong can be amended at all. So according to this interpretation issued by the NPCAC will not just have a backseat role in approving the electoral model passed by the Hong Kong legislature, it will also have an initiating role of deciding whether the amendment procedure can be kick-started in the first place. The NPCAC's recent decision in August to impose restrictions on the nomination process is a decision to kick-start the procedure for political reform. The decision determined that universal suffrage of the chief executive can be introduced in 2017, but the nomination procedure must follow the strictures laid down in that decision. The decision also determined that the method for forming the Legislative Council shall remain the same in the next election, meaning that half of its seats will continue to be returned by functional constituencies.
Cora, there are a lot of parts in what's going on right now in Hong Kong. For me, there are two facts. The first fact is that people are very upset about the decision that happened in Beijing, the decision of the NPCSC. And the other fact is that the NPCAC made a decision. Now I wonder, is there, as a matter of law, validity to the decision made by the NPCSC? In other words, do the people have a legal or constitutional basis upon which to complain about the decision of the NPCSC?
Well, there are various ways of looking at this question. One way would be to examine whether the constraints imposed by Beijing on the nomination process comply with Article 45 of the Basic Law. This article, as we've seen, states that the ultimate aim shall be selection of the chief executive by universal suffrage upon nomination by a broadly representative nominating committee according to democratic procedures. The constraints imposed by Beijing potentially violate a natural reading of this provision in at least two ways. First, if, as Beijing's decision dictates, the size, composition, and formation method of the nomination committee is to be based on that of the existing election committee, then the electorate base of the nomination committee would be very small. There would be an overrepresentation of pro-Beijing business tycoons, and the committee would fail to meet the Basic Law's requirement of it being broadly representative. Secondly, if, as the NPCAC's decision stipulates, someone can only stand for election after obtaining more than half of the support of the nomination committee, 50% support from the nomination committee, then people with political views that are not mainstream within the nomination committee would be precluded from standing for election altogether. And given that most members of the nomination committee would likely be pro-Beijing, such high nomination threshold, a 50% threshold, would likely preclude pan-Democrats from running for the chief executive altogether. This would violate the Basic Law's requirement of the nomination committee having to return candidates through democratic procedures. However, since the NPCAC has the final power of interpreting the Basic Law, it can, of course, at any time, although it hasn't done so yet, it can at any time issue a formal interpretation of Article 45 of the Basic Law to import the NPCAC's idiosyncratic understandings of terms like democratic procedures and broadly representative. So to fully assess the legality of the NPCAC's decision, it would be necessary to look beyond the framework of the Basic Law and evaluate whether Beijing's decision complies with Hong Kong and China's international obligations. The International Covenant on Civil and Political Rights was entrenched in Hong Kong through Article 39 of the Basic Law. The ICCPR Article 25 guarantees that citizens shall have the right to vote and stand for election in genuine periodic elections with equal and universal suffrage and without discrimination and unreasonable restrictions. Onerous restrictions over who can stand for election may constitute unreasonable restrictions and are potentially discriminatory on the ground of political views. The Chinese government argues that this ICCPR provision on political rights is not applicable in Hong Kong. And their argument goes that when the UK extended the ICCPR to Hong Kong, the UK made a reservation saying that this provision on political rights doesn't require Hong Kong to set up an elected legislature and an elected executive. However, the UN Human Rights Committee has made it clear that although Article 25 of the ICCPR does not require Hong Kong to set up an elected legislature or executive, still the UN Human Rights Committee is of the view that still, once elections are introduced in Hong Kong, once you introduce elections, the election methods have got to comply with the requirements of equal and universal suffrage under the ICCPR. In fact, just last week, the UN Human Rights Committee urged China not to impose unreasonable restrictions on the right to stand for election in Hong Kong. So it would be fair to say that an electoral model that is designed according to the stringent restrictions laid down by Beijing would very likely violate the ICCPR's requirement of free and non-discriminatory elections.
That seems reasonable to me. It also seems that the battleground here, as a matter of formal law, is whether the decision of the NPCSC can be amended, revoked, or even challenged in some way. Can it?
Well, the protesters are calling for the NPCSC to withdraw or amend its decision. Legally, this is possible. Legally, the NPCAC can issue a new decision to override its previous decision. Also, according to the Chinese Constitution, the National People's Congress can also revoke a decision made by its standing committee, the NPCAC. However, politically, such revocation or withdrawal is extremely unlikely. It's unlikely that Beijing is going to have the political will to change its decision. And the Chinese government has stated many times that it would not change its decision, and it's not difficult to see why. First, Beijing has all along justified its tight screening mechanisms on the ground that without such screening, someone who isn't patriotic may be elected as the chief executive, and this would endanger national security. Well, national security defined in a broad sense to include the stability of communist rule. This so-called national security concern, from Beijing's point of view, is not going to go away even if people in Hong Kong have gone onto the streets. If anything, this concern may even be heightened in view of the protests, because Beijing considers these protests as having been fueled by so-called foreign forces. Also, another consideration is the Chinese government worried that if it gave in to public pressure, then people in other parts of mainland China would follow Hong Kong's example and would begin to organize large-scale protests to pressure the Chinese government, and this would ultimately threaten communist rule. It is therefore unlikely, highly unlikely, that the NPCAC will withdraw its decision on its own volition. Well, you may ask, well, then can Hong Kong organs compel Beijing to withdraw or amend its decision? The Basic Law provides no mechanism for Hong Kong organs to challenge Beijing's decisions. It is an unsettled question whether the NPCAC's decision can be challenged in Hong Kong courts. In 2001, Hong Kong's Court of Final Appeal controversially and very boldly held in the case Ng that Hong Kong courts could review and strike down decisions of the NPCSC that violated the Basic Law. This ruling was so controversial that the Hong Kong government had to ask the court to clarify what the court meant by it being able to strike down decisions of the NPCSC. And in its clarification, the Court of Final Appeal stated that it had no power to question a decision of the NPCSC if the decision complied with the Basic Law. So essentially repeating its original position in more palatable terms. But the question of whether Hong Kong courts can challenge Beijing's decision is inconsequential for two reasons. First, Hong Kong courts have already accepted that the NPCSC has the final power of interpreting the Basic Law. If the NPCSC issues a formal interpretation of Article 45 of the Basic Law, that is the provision on universal suffrage, Hong Kong courts would very likely accept without question the NPCSC's idiosyncratic interpretations of universal suffrage. Secondly, even if Hong Kong courts were so bold as to reject Beijing's understandings of universal suffrage, and even if they were so bold to rule that Beijing's stringent conditions on the election method violated the ICCPR as entrenched in the Basic Law. Even if this were to happen, still, there is no mechanism for Hong Kong courts to enforce this judgment against Beijing. Finally, we mentioned the ICCPR. In relation to the Hong Kong's government possible breach of ICCPR obligations, the problem is the lack of an effective enforcement mechanism against such breach. So even if the NPCSC's decision doesn't comply with the ICCPR, there is no effective mechanism of compelling Beijing to change its decision.
So the decision of the NPCSC seems unlikely to be altered, either by amendment, by revocation, or as a result of a challenge. And so therefore that raises a question for me, which is whether the protesters in Hong Kong have been protesting in vain.
No. My answer is a definite no. Well, despite the political reality that Beijing will not withdraw its stringent screening mechanism at this point of time, the large-scale protests in Hong Kong are still significant in at least three ways. First, the protests will hopefully convince the NPCSC to relax its restrictions on the nomination process in future. So it can't change things now, but hopefully in future the NPCSC might change its mind. Secondly, the protests will put pressure on the Hong Kong government to try to get the best deal on democracy for Hong Kong people from Beijing. Protest leaders have been demanding the Hong Kong government to ask Beijing for a timetable and roadmap on when and how genuine universal suffrage will be introduced. So the protests will put pressure on the Hong Kong government to do better, to get a better bargain from Beijing. Thirdly, in the coming months, the Hong Kong government will launch public consultation on the details of the election method. So the NPCSC has laid down the overall framework, the constraints, but the details of the election method still have to be sorted out. The government is going to conduct consultation on this matter, and subsequently the Hong Kong government will formulate an electoral model, a precise electoral model for the Legislative Council to consider. The protests will put pressure, hopefully, will put pressure on the Hong Kong government to try to democratize the election method as far as possible within the constraints imposed by Beijing. And the Hong Kong government can try to do so by, say, expanding the electoral base of the nomination committee through reducing corporate votes. So the protesters are not protesting in vain. Hopefully it will lead to some difference in the democratic road in Hong Kong.
So you're painting an optimistic portrait of the effect of the protests, and let's hope that will be the case. Cora, thank you so much for helping us understand what's going on in Hong Kong, the relationship between Hong Kong and China, the impact of the decision of the NPCSC, and perhaps what the future portends for the democratization of Hong Kong and China, Hong Kong within China. One more question before we go, if I could. How did you get interested in comparative public law?
Thank you very much, Richard. I've been fascinated by public law ever since I was an undergraduate at the University of Hong Kong, and my interest in comparative public law really began when I read the BCL at Oxford, where you and I met. Richard and I are classmates at BCL. In Oxford, I was exposed to the constitutions and public law cases of other jurisdictions, as well as constitutional theories that transcend jurisdictions. And I found it fascinating, very interesting to apply theoretical concepts like sovereignty, devolution, separation of powers to different jurisdictions and compare how these concepts are manifested. I also found the constitutional arrangements in other jurisdictions inspirational for addressing public law issues in my home jurisdiction. So that was how I became interested in comparative public law and comparative human rights.
Oh, well, fascinating. Thank you so much. I've learned personally so much from your work, and I know I will continue to do so. So thank you for your time, and I look forward to seeing you some point very soon.
Thank you so much, Richard. The privilege and pleasure is all mine.
Okay, thank you. Bye, Cora.
Thank you, Richard.